After 8 solid months and a decision from SCOTUS on Rahimi, we finally see an opinion from the Ninth Circuit on the May v. Bonta case. This one having to do with sensitive places. Looks like we got some wins and looks like we got some losses. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we finally got a decision from the Ninth Circuit Court of Appeals on the May v. Bonta case, as well as the Wolford v. Lopez case. Here to talk us through that today is Chuck Michel. He is the founding partner of Michel and Associates, as well as the president of CRPA. Chuck, thank you for being with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. But before we get into that, guys, please be sure and like, share, and subscribe to these videos. We're trying to get this information out to as many people as possible, and it really helps with the algorithm. Right now, it's really focusing on that like button, so please go ahead and give that a smash for us. We want to be as vigilant as possible, especially with this kind of opinion coming down from the Ninth Circuit. So, Chuck, can you just walk us through this really quick? At least the May v. Bonta case, put us through a little bit of a roller coaster at the beginning of the year. Can you give us a quick background on what the case is and its crazy path through the courts so far?
Well, yeah, folks, remember, there's already laws that essentially prohibit the possession of a firearm, a concealed firearm or a loaded firearm in public. And there are exceptions to that for transporting it from place to place in a locked container, unloaded. So generally, though, you can't carry a firearm around in public unless you have a license, a concealed carry a concealed weapon permit, referred to as a CCW, typically, that gives you the permission to carry in a holster a loaded firearm in public. Now, for 100 years, it's been that way. After Bruin came down, and there's been no incidents, people with CCWs do not cause problems. Now, when Bruin came down, it said that states like California, which had been very, very stingy in issuing CCWs, they didn't want people to be able to get these licenses, and so there was a big disparity between red counties where certain sheriffs were inclined to issue, and states, cities like San Francisco or Los Angeles, where they didn't want anybody to have one. And so they would set the bar very high and require some kind of good cause that typically meant the only good cause they would accept was like a stalker that was, stalking you and had threatened you, and they had his name and address. And I mean, it was ridiculous, the requirements that they had to get a CCW in some of these cities. Then again, in other cities like Orange County, after the CRPA won the Peruta case at the trial court level, I mean, it's the appellate court level, the 3-judge panel level, some cities saw the light, and counties saw the light. So Orange County, Riverside County, a lot of counties started issuing permits, licenses. But when Bruin came, because they said that you had good cause, that's basically, they were saying self-defense is good cause. When Bruin came down, it said you can't require people to identify some specific need to carry. Generally, self-defense is enough to satisfy the Constitution, so you have to give these people licenses. So a lot more people started applying for licenses. And we have about, last time I talked to Rick Travis, we have almost 400,000 people with licenses in California now, whereas it was about 200,000 before Bruin came down. And we wanted to get that up to a couple million. But Gavin Newsom and his politician friends do not like the fact that you can get these CCWs, and so they've been doing everything they can to try and make it as difficult as possible, throwing down roadblocks in the way other than good cause, like excessive training or expensive psychological examinations, lengthy wait times. And CRPA has a lawsuit going on about that one against the LA County Sheriff right now because they're taking too long and they're charging $1,000 to get a CCW. But in the meantime, one of the things that the California legislature did was pass SB 2, Senate Bill 2, which basically made your CCW invalid in many public places. So what they're trying to do was make it so that people wouldn't bother applying for a CCW because it was invalid. They were trying to make it effectively useless because CCWs wouldn't allow you to possess in so many places. So that's what we challenged in the May v. Bonta case, and Hawaii challenged in the folks in Hawaii challenged in the Walford case. And there was a Caballeros case by our friends at Second Amendment Foundation and FBC and other groups that challenged it as well. So there was sort of a coalition of groups that got together and filed these 3 lawsuits, and they were all heard together. And finally, we got the ruling on all 3 of them last week. And it was a mixed bag. We got let me just find the list here. Okay, so we filed a lawsuit in the district court, and we got an injunction. In other words, we stopped the law from going into effect. So your CCW was still good every place that it had been good for the last 100 years. It wasn't limited. The state appealed that, and the Ninth Circuit 3-judge panel just came down last week with the ruling that said that the places where you can still carry with the CCW are hospitals, churches, medical facilities, public transit, gatherings that require a permit, and the parking areas attached to those places. And they also struck down what we've been calling the vampire rule. You know, in folklore, a vampire can't come into your house unless you invite them in. Well, the law required businesses to post a sign that said guns allowed, as opposed to a sign that says no guns allowed. Now, most businesses are not going to go to the trouble of posting a sign that says guns allowed because they know it's going to freak out some people. And that's what the politicians knew too. So they were trying to make it so that most businesses would not bother to post that sign, and thereby most businesses would be prohibited from firearms. CCWs would be prohibited in most of those businesses. So he struck down the vampire rule. So now when someone owns private property, a business owns a private leasehold, it's private property. You can tell people they can't bring guns there. You can tell people that they can't bring, a can of Coke there. You can tell them anything. It's your property. You can regulate it. It's not a government action. So governments, these private properties can still ban firearms, but they may have to post a sign saying we do not allow firearms on this property, or not. I mean, they may just tell somebody if they come in with one that they don't want guns on the property. The point is that the government, when it's acting as a government, can't ban your rights on private property. Sometimes they can. So we got the vampire rule struck down. But where we lost was bars and restaurants that serve alcohol, playgrounds, parks and state parks, which is a problem because there's wild animals, and when you're camping in a state park, you can't have a firearm to defend yourself against bears or cougars. Casinos, stadiums and arenas, libraries, zoos, museums, and the parking areas attached to those places. So this is still very confusing and not very well thought out in many respects by the Ninth Circuit panel, because they haven't answered the question about whether or not, what if there's a parking lot that has a hospital and a bar adjacent to the parking lot. You're allowed to have it for the hospital, but not for the bar. What about state parks where you're going to go hunting, or where guns are typically have been allowed, or federal parks? So there's still a lot of questions, and my team at the law firm is putting together sort of a detailed analysis on this. Remember, without a CCW, the classic way, the typical way that you carry a firearm around is in a locked container, unloaded. So can you then take your CCW firearm, unload it, put it in a locked container, put it in your car, and now you legally possess it in that parking area where otherwise you can't use your CCW? These are the kind of things that we're getting tons of questions about, and we're trying to get the answers together for.
Well, something that I've actually gotten a few questions about, and I thought was actually highlighted in the opinion itself, I wanted to read this to you and get your thoughts on it. It goes like this. With respect to sensitive places, however, those concerns are diminished. Our nation has a clear historical tradition of banning firearms at sensitive places. When examining whether a particular place falls within that tradition, a small number of laws, even localized laws, can suffice if those laws were viewed as non-controversial. Nor did the founders have a rigid conception of what kinds of places qualify as sensitive. The Supreme Court held that schools qualify as sensitive places because of localized, non-controversial laws that were prohibited firearms at a few schools, and those laws were first enacted in 1824, more than 3 decades after the ratification of the Second Amendment. The relevant regulation of firearms at sensitive places existed at the founding. So just a point of clarification here, and this is the question that I've received a little bit. This fight is not necessarily about making carrying a firearm legal on sensitive places. This fight is about how the state is classifying areas as sensitive. And that was also directly discussed in the Bruin decision. But I was also curious if you could provide clarification on that. Talking about just as a foundational point, they're saying that these were, this is permissible if these laws are non-controversial. What the heck do they mean by controversial? I'm sorry, talking to a layman here, but the fact that we brought up a lawsuit, doesn't that kind of make this law controversial? How is it exactly that they move forward here with this framework stating that these laws aren't controversial?
Well, they're saying that historically, bans of firearms in certain places was not a controversial notion. People accepted it. But the point they're missing is we're not talking about gun-free zones. We're talking about CCW-free zones. In those historical analog laws that they talk about, they were talking about banning guns entirely, but they didn't get into whether or not there were exceptions for people, and there always are, for certain people, whether you're a police officer or a bounty hunter or whatever it may have been in the olden days, to bring your firearm into those places where firearms were otherwise banned. We're not talking about banning all firearms from a place, no matter if you have a CCW or not. And neither were most of those historical laws. What they were talking about was banning most people. But they didn't get into whether or not there were exceptions, or what exceptions there were for people who were effectively licensed, whether it was a CCW or a badge or whatever it may have been. So the court's comparing, in many cases, apples versus oranges here. These are not the same kind of historical analogs. And that's one of the things that we're going to have to clarify with the trial court, because what's going to happen next is we have to decide. We have 3 things we could do. We could seek en banc review by an 11-judge panel from the Ninth Circuit to review the 3-judge ruling. We could go straight to the Supreme Court, which is not a good idea right now because the Supreme Court is not taking, and has made it clear they prefer not to take, cases that are still in the preliminary injunction phase. Remember, when you file a lawsuit, you file a complaint, you seek a preliminary injunction, and if you win or lose, the loser can appeal that to the Ninth Circuit. It's called an interlocutory appeal, because even while that's going on, the trial court case continues to move forward towards a permanent injunction and a judgment. And the Supreme Court likes to hear cases where there has been a judgment entered, so the case is final, not the preliminary injunction where they still have all this work to do in the trial court. So we're most likely going to have to go back to the trial court and point out some of these inconsistencies with the Ninth Circuit's ruling, and submit the evidence and do all the work to show the trial court judge that these historical analogs were not on point. They weren't the relevant analogs that they need to be in order to justify a modern day gun control law.
So we got the opinion, and it upholds part of the injunction that we had at the federal district court. It also overturns some of it. And guys, if we went through every single one of these arguments within the case, this video would be well over an hour long. I'm going to have Jacob put the opinion in the description below. If you are a CCW holder in Hawaii or California, this is definitely one that you want to read in its entirety. Obviously, we are going to be posting updates to the CRPA website just as soon as they come out. This is one that you want to be informed on because the law has changed. But Chuck, if you could, the big ones, as far as the wins and the losses in this opinion for gun owners in California, can you just roll through them really quick? I know the vampire rule is a big one.
Yeah, the vampire rule is a big one. Public transit is huge because they wanted to stop people from being able to take a firearm on a bus or a train to go from one place to another. And a lot of people rely on public transit. They don't have a car. So that's a fairly significant victory. I would say churches are a big one too, because a lot of churches want to have an armed security detail there. And if you've seen some of the social media videos where somebody goes into a church and tries to start something up and they quickly get taken out by some of the armed guards there, that's a good ruling. Again, my big problem is zoos, parks and state parks, and the parking areas attached to those places. Remember, again, if somebody owns a casino or a museum and wants to, because they're a private property owner, they want to prohibit firearms there, they can. It's private property. Why does the state have to ban them for everyone? Just make that decision for the private property owner. It's not the way things are supposed to work. But in the meantime, we just have to go. We will be putting out an exhaustive explanation of some of these rulings and what they do and how you can work around them. Whether you can, if you go into one of these areas, can you unload your gun, put it in a locked container, put it in your trunk, and have it there until you're off that particular piece of land, that sensitive place where the CCW is invalid. So that people need to subscribe to CRPA and watch for that memo. We will be getting that out probably this week. And then we'll be going back down to the trial court and making some of these points.
Yeah, I could definitely imagine that anything outdoors is going to be an issue if a CCW is banned. You think about, state parks where people want to go hiking, people go hunting. You have the opportunity of running into a predator where you might need to defend yourself. Those also tend to be places where people are targeted because law enforcement is at a complete minimum. To be honest, I would be remiss if there weren't a lot of people that, when it was necessary, put hiking as a reason to get a CCW because law enforcement was so minimal. So I guess, Chuck, from here you laid out a few options. It seems like the case isn't ripe enough to get an appeal to the Supreme Court because this is just for a preliminary injunction. What kind of timeline do you see going forward as far as us following along?
This case in the trial court will probably take 6 months to a year as it moves its way through. Hawaii may go faster. I think Hawaii may jump to the en banc question sooner because they got a little bit worse of a ruling on the vampire rule. So we'll see what they decide to do. But in the meantime, look, this is all still about methodology. We've talked about this before. The big question, no matter what kind of a case it is, whether it's a prohibited place case, a prohibited person case, or a prohibited firearm case, the methodology that's supposed to be applied under the Bruin test has still got to be clarified. And so that's why the cover of the CRPA magazine this month has the big Bianchi on the cover. That's the case, the Bianchi case out of the Second Circuit, which upheld an assault weapon law, a semi-auto ban. That case went to trial and there was a final judgment, and that case is now in front of the United States Supreme Court, and the Supreme Court we hope will take that case, and the CRPA and the Second Amendment Law Center and all our strategic partners at Second Amendment Foundation and Gun Owners of California and Gun Owners of America and FBC and all the other groups that I'm forgetting will all be asking the Supreme Court to take that case. And then if it takes it, we'll all be asking the Supreme Court to strike down that semi-auto ban, because that will have precedential effect. That will be binding legal precedent in Illinois, in California, in Oregon, in all these other states that have semi-auto bans. And it'll also, in the process, clarify the methodology, which will come in handy in this May case, prohibited places case, and every other case that we're litigating. And we have dozens, CRPA has dozens of cases working their way through the system right now. Duncan is probably second in line for a Supreme Court review, because that's in the Ninth Circuit en banc right now, having been issued a judgment. So that we're looking for that one to come down any day now too. And as soon as it does, we'll go to Supreme Court if we didn't win.
Well, certainly a lot to look forward to, not just in this case, but in all of the other lawsuits that are ongoing as far as recouping our rights is concerned. Chuck, I know you're a busy guy. You got a lot of work ahead of you. I appreciate you taking the time to come on. Thank you very much for being with us today.
Hey, thank you. And thank you everybody who supports the CRPA and all the litigation efforts that we've got going. We give generous rates to the CRPA as a nonprofit, but still it takes a lot of time to litigate these cases, and we need the support. We need the support of all the members and donors to help keep doing this work, because it's so critically important to get done.
Absolutely, and thanks again. And guys, if you like content like these, you like these videos, you like being informed, please, once again, be sure to like, share, and subscribe to these videos. It really helps with the algorithms push this message out as far as it can possibly go, especially with the 2024 elections coming up. Chuck said it earlier in the video, CCW holders are not the problem in California, which makes legislation like SB 2 political, not about safety. So if you want to change that landscape, if you want to directly contribute to the litigation and the legislative efforts, if you want to get the right people in office, please be sure to go out and vote with the Second Amendment as a high priority. We hope these videos help get you there. Thanks, guys, and we'll see you on the next one.